with me today I have Dennis Gingold, who has been the head litigator on this case since the beginning of time, since we filed the case. And then also with me today is Alex Pearl, who is an attorney that just started working with us, but is doing one great job. You know, there's so many facets to this lawsuit, and, you know, I thought that once we got to the settlement and that we just had to get it sort of sprinkled holy water by the Congress. And, you know, every time you work with Congress, it's like educating, because they get all confused, and just telling them, or trying to inform them that this is an individual Indian class action lawsuit. And of course, we'll get into a little bit more depth later, but, you know, they go, oh, you have to get tribal approval. You have to get, I said, no, tribes have nothing to do with this. This is individual Indians. Tribes will benefit, but we need to get out and tell the individual Indians about this case. And of course, we tried right at the very beginning after the settlement. We asked the government to put in some money so we could start getting out to grassroots individual Indian communities and explaining, and they said, no, you don't have a settlement yet. You don't have a settlement until Congress approves it. So basically, we came anyway because we thought it was so important. And one area that we were facing so many rumors. Everybody was just like going rapid with rumors, you know. Oh, they had me getting $15 million, and they had, you know, everything from soup to nuts. And so we just thought, in order to alleviate all these rumors, is we really need to get out and we need to give you the facts. And we need you to ask your questions. And so that's why we're here today. And just to go a little bit further back is, you know, we filed this lawsuit in 1996 on behalf of over 500,000 individual Indians, and basically for an accounting for trust monies, because the government had never ever given us an accounting. And then as time went by, and let me tell you, we had some very major victories in this case. And the first victory was when the judge ruled in 1999 that the government was in breach of trust and they had to fix all the accounting systems. And then as time went by, we had a wonderful judge that gave us some really good decisions. And of course, every time you battle with the United States government, they have the upper hand, and they went to the appellate court and got our judge removed, and he was removed. They said he was biased, the government. And so they gave us a brand new judge, you know, very late. And the new judge really didn't do a lot of favors for us in this lawsuit. And I know Dennis will go into more detail, but I just want to give an overview. And when he ruled that all that was due us, well, let me tell you that the government argued all the way through this that they owed zero. They did not owe any money to individual Indians. Zero. And they got up before appellate courts, whatever, they had, no money was missing. No money was missing. And that was the argument that we had to always go against. And of course, the government destroyed all the documents, and so, you know, it was hard to deal with. But then the judge ruled that they owed $455 million, and that was it. And so then that, of course, we appealed that, and then the appellate court came back and said, well, you know, we're just going to throw everything back to the district court again, and you don't have to worry about doing a legal accounting. You can do an accounting and for whatever type of money you have, government, and you can take as long as you want for this accounting. So it was at that particular point in time that we knew that we had to settle, but we didn't make that decision. Who made the decision was the judge. The judge called the plaintiffs in, us in, and the government in, the defendants, and basically told, the way I see it, there's no judicial solution, that you will be in court forever. So President Obama had made a commitment to Indian country that they were going to settle this case. And so working with that commitment, we went into negotiations with the government, and that's when we came up with the $3.4 billion settlement. And it has many facets to it, and Dennis will go further into it, but I have to tell you that I think out of the $3.4 million, which it's very beneficial to everyone, but the most beneficial to me is the fact that, you know, we have a $60 million scholarship fund out of this deal, what is very important for our children going forward. And like you'll hear today, is this case isn't a fix-all for everything. This is a stepping stone. This was a huge victory, and it's a stepping stone to continue the work that has to be done. But what we did do, and I want you all to remember this, is what we did do is we brought individual Indian trust to the forefront. We are in front. So that's sort of the overview. I think what I'll have Dennis do before, probably most of the questions are going to be legal questions, and I'll try to answer as many as I can, but I'll have Dennis do the overview of the settlement itself.
Good afternoon, and I also apologize for us being delayed. We did everything possible to get here on time. We were not good at it. And we will spend as much time as necessary with you all in order to answer all your questions to the best we can. If we don't know the answer to your question, we will tell you. If we believe we know the answer, we will tell you that. We're not going to spin this. We're not going to give you a political speech. And we may even offend people with some of our responses. But what you're going to get from us today is the truth as we understand it, and the facts as we understand it, and why we believe we are where we are today. And it took a long time to get here. Let me raise a couple of questions and answers with you first that have been asked to us in the earlier meetings. Sure, by the way, can you hear me?
I can.
Okay. I'm going to be getting a microphone. So I guess okay, why don't I stand up? In the discussions we've had on Pine Ridge yesterday and today, a number of questions have come up, which are very good questions. And I think they're on the minds of a lot of people. And we ought to deal with those up front because there is actually an easy answer to these questions, but they're important. One of the questions we were asked is, will the tribes be able to get this money? Some people have borrowed money in tribal credit programs, and the question is, are the tribes going to be able to take my money and pay back what I owe? The answer is no, they can't. There's a reason for it. The money is going to go directly to them. It's not going through their individual Indian trust accounts. So they'll be getting a check directly to each beneficiary who has had an IIM account and or has had land. If you're in one of those two categories, you're going to be getting a check. Every individual Indian trust beneficiary who has had a trust account will be getting $1,000 just for having that trust account, whether or not, in the history of the account, $5 went through the account. So $1,000 is going to come right off the bat. And one of the more important things is, too, we want to, and remember, we're dealing with $3.4 billion. We're dealing with 1.4. That deals with the accounting issues and the funds and land management issues. We're dealing with $2 billion. That deals with the government's desire to buy individual Indian trust land solely if the individual wants to sell it. If the individual doesn't want to sell it, it doesn't make any difference if the purchase price is $1 million, $5 million, or $1. The individual doesn't have to sell it. That's very important. But the $2 billion would be used to pay for those fractionated interests, in addition to the other monies, and there's more on top of the $1,500. But the $2 billion would then go directly from the government to the individuals. If they choose to sell their land, the land would be purchased solely by the government for purposes of restoring that land to the tribes. The government can't keep the land. So basically, the tribes, even though they had nothing to do with this litigation, the tribes are going to get a $2 billion gift. The lands that they've been complaining about that were taken from them unlawfully in 1887, $2 billion worth of those lands will be restored to the tribes. That's a significant benefit. The argument to the government for that is the fractionated interest is making the management of the individual Indian trust difficult, if not impossible. Accordingly, if they're able to consolidate those interests and then restore those interests to the land, they'll be able to be restored in a way that can make the land productive in the future. We represent in this class over 500,000 individual Indian trust beneficiaries. Some have fractionated interests that are tiny, that go to 3 or 4 or 5 decimal points, as they've been inherited over the years, generations. Some are larger, some are 40 acres, some are more than that. But one of the aspects of this case is most of the trust land involves interests in undivided interests in a whole. Hello?
Turn it on. Turn the mic on.
Hello? 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 I'm trying.
Oh.
Track that one.
Okay. Hello?
Voices.
Hello? Hello? Okay. So the interests in land are undivided interests in whole acreage, whether it's a very small fractional interest or a third of whatever the allotment is, or more than that. It includes also the fractionated interests in subsurface rights, the oil and gas rights and things like that, and of course the surface rights, depending on the particular individual and the area of the country, also includes the timber rights. So these fractionated interests are extremely valuable, quite frankly. They're worth far more than $2 billion. As a matter of fact, we're talking about approximately 11 million acres of trust land that is held for the benefit of individual Indians. We don't even have a fair estimate of the value, but it could be hundreds and hundreds of billions, if not more, in value. Because remember, it's oil and gas, it's timber, it's gold, it's coal, it's grazing, it's farming, it's other sorts of rights, including sand and gravel and even water.
Mineral.
We're talking about the wealth of this country is in the individual Indian trust. So $2 billion doesn't represent an acquisition of the trust land. And if individuals want to sell their land, it is their land. They can do so. I would recommend that if anyone sells his or her land, it be done at fair market value. And that's one of the reasons that it would be done this way. Nobody must sell the land unless he or she wants to. Very important. So we're dealing with a huge benefit there too. With regard to the base value on resources of $500, with regard to this management of the lands and the revenue that was generated from these lands. Some of the beneficiaries in this class are going to be receiving more than $1 million. Many beneficiaries are going to be receiving hundreds of thousands of dollars. And by the way, whether it's $1,500 or $1,100,000, it's tax-free. One of the things we negotiated in this agreement is that the recovery, the payments of the beneficiaries would not be included in your taxable income. Secondly, and this is important to many of the beneficiaries, none of the payments that would be made as part of the settlement would disqualify a person from his social entitlements programs that he or she is entitled to today. That means whether you got a check for $1,500 or $5,000 or $1 million, today you would still be able to continue to participate in your entitlements program, and this payment would not disqualify you in the future. It's very important. Now, how the money is going to be distributed above the baseline that we're talking about. The baseline effectively is $1,500 per person. Will depend on the income that went through the trust account since 1985. And basically the 10 highest years of revenue would be averaged, and a formula is used to determine how much individuals would be getting. We know, for example, and let me give you other areas where trust beneficiaries have had significant revenues. An example would be the Osage in Oklahoma, the oil and gas revenue. Another example would be certain Navajo. 52% of all the natural gas that is used in Southern California is piped across the Navajo Reservation. That's very big. In addition, Agua Caliente in Palm Springs, California. The Agua Caliente actually own Palm Springs, and they lease it, which means it's a very productive revenue source for the Agua Caliente, historically and in the future. And then you have individual Indians from Salt River in Arizona. Salt River leases the land to Scottsdale. Scottsdale, Arizona is on Indian land. Water is also very valuable. All of that means very valuable income has been provided to Salt River individual Indians. And then all the highway and road rights of way go across the individual and tribal land in some instances. And then another very significant pocket of income is in the Pacific Northwest. Timber, huge over many, many generations. And so we're looking at individuals who've had significant revenue, where the likelihood is, from what we've seen from the records that have been produced, they've had the most that's been stolen from them over the years, quite frankly. This is the first time I've been in South Dakota. We are aware, we are very acutely aware of the various South Dakota tribes in the Great Sioux Nation. Much of the land, however, hasn't been used for oil and gas, hasn't been used for timber, hasn't been used, for Scottsdale, Arizona, or Palm Springs, California. This is South Dakota. As a matter of fact, many of the accounts have had very little, if any, money going through them, and some of the land has never been leased. Nevertheless, those people are going to be getting $1,500. This was an action in equity to enforce the trust duties of the United States. And we're not asking for more. We're trying to get that to which you are entitled. And if, in fact, you only had $10 going through an account on an annual basis over a 10-year period, that still doesn't add up to $1,000. You're going to be getting an income. If you've had much more than that, the type of thing I was talking about, you're going to be getting it. But this has to be broken down still over, from this part of the settlement, $1.4 billion. We can't give everybody $1 million because if you give 500,000 people $1 million, it's more than $1,400,000. The government, no matter what we did, would not go beyond $1.4 billion. Now let me tell you something. Whether we're talking about $1.4 billion or we're talking about 3.4, which is what the settlement is, it is the largest settlement in the history of the United States. That includes all the tribes aggregated in the history of this country. That includes all the companies, whether we're dealing with a defense contract or anyone else, who sued the United States. This represents the largest settlement in history, and it's not for corporations and it's not for tribes, it's for individual Indians. That is a significant statement, historically and otherwise. I am not an Indian. That status isn't going to change. I was born that way. You're Indians. Your status isn't going to change. You were born that way. I know you've heard white lawyers coming from Washington lying to you, and you've had the government coming from Washington lying to you. For every generation, you people have existed. I'm not here to lie to you. If I was going to, Eloise would slap me around. She's black for
Slap you anyway.
So we're here to tell you the truth. We're not trying to trick you. We're not trying to use clever language. We're not going to tell you that this is the best thing since sliced bread, because if it isn't. It is fair under the circumstances. But if we had our druthers, we would want a lot more than this. I want you to know that. But it's not possible. We're dealing with difficult courts. We're dealing with a Congress that is difficult. Matter of fact, right now in Congress, there are members of Congress who are saying, this is too much. We don't want to do it. This is fiscally irresponsible. And so we're dealing with a number that I think we believe is feasible to get done in the political environment. We're also dealing with trust law. We're not dealing with Indian. You are trust beneficiaries who happen to be Indians. That's the important aspect here. And because of that, it's the government who is your trustee. Let me just explain briefly what the trustee or the trust relationship is. It is a unique relationship. It means, in the words of Justice Oliver Wendell Holmes, that the conduct and standards of the marketplace aren't good enough. That the conduct and actions of the trustee are to be subject to the most strict judicial scrutiny and must meet the highest standards because the trustee is to act in the best interest of the individual Indian beneficiary, not in the best interest of itself. And that applies to Indians as much as it applies to anybody else. You're not taken out of the Constitution. You're not removed from 800 years of trust law as it has evolved, has been adopted in this country, and has continued to evolve in this country. There is no exception for Indians. There's no exception for the government. As a matter of fact, Mitchell II, which is a 1987 United States Supreme Court case, specifically says, whereas here, the United States government has exercised control over individual Indian trust lands. All the duties and responsibilities of a traditional trustee apply to the individual Indian trust, unless Congress expressly or by necessary implication, through legislation, eliminates or restricts or limits those duties. Congress has never done so. Treaties have nothing to do with this. What we're dealing with, trust law, what legislative provisions constitute collectively the trust instrument, and how they are interpreted. A normal trust has a trust instrument, which defines the trust, identifies the duties and responsibilities, identifies the trust beneficiaries, has a termination, and settles and provides the assets that are the basis of the trust, which are called the trust corpus. This doesn't have a single instrument. Nonetheless, one of the government's experts, a professor from Yale Law School, Professor Langbaum, testified as to what the trust instrument is in the individual Indian trust. It is all the legislation that has been acted by Congress that affects the trust relationship of the United States to individual Indians, not the trust relationship of the tribes to individual Indians, and nothing else. In 1887, the Dawes Act was passed. The Dawes Act was passed to put all the individual Indian lands into trust with the beneficial interest held by individuals and the legal interest held by the government as trustee. Whether we like it or not, that act was held to be constitutional. But that act itself didn't create trust obligations. What the United States Supreme Court said was as follows. Once the act was passed, and after the United States government exercised control over trust land, from that point forward, the duties and responsibilities of the government were the same as any traditional trustee. Whether it's J.P. Morgan Bank or Citibank or Wells Fargo or any trustee, it's the same thing. That's what we sought to do in this litigation. One of the reasons this litigation was a class action as opposed to an individual action was because all the revenue from the trust land is commingled. And let me explain this. You have leases. You have leases that cover individual Indian trust land, and they're even communitized with tribal leases. All the funds that are collected from BLM lands, from individual Indian trust lands, and from tribal lands are collected in common, deposited in minerals management service accounts at the Treasury. They are then allocated between the government, tribes, and the individuals based on bad records on our area. The individual monies are collected and put in an account, the 14X6039 account at Treasury, and the funds are invested and reinvested collectively, and they are allocated for disbursements. It is a collective investment trust, a commingled trust. You cannot do an accounting of one person accurately or completely unless you do an accounting for everyone. That's at the fund level. And by the way, the investments are, when they're made, they're invested in various instruments, Treasury bills, Treasury notes, and at certain points of time throughout the history of the trust, savings bonds, liberty bonds, war bonds, and other notes of that sort. We have testimony from Treasury Department officials, including the Assistant Secretary of the Treasury for Financial Management, that individual Indian trust funds have been used to reduce the national debt. And indeed, I believe they are still being used to reduce the national debt. We brought this action not for damages. We brought it for an action. The action is an action in equity to enforce the trust duties of the United States. We wanted restitution, not damages. Restitution includes the recovery of the assets that are the beneficiaries, the restoration of the trust. It is measured by the benefit conferred on the trustee, not by the harm to you. The burden of proof then remains on the trustee. It doesn't shift to the plaintiffs to prove the harm. That is a huge difference, and that is something that can be done in the United States District Court, but it cannot be done in the United States Court of Claims. The United States District Court judge sits as a chancellor in equity. As chancellors in equity sat 700 or 800 years ago in England. The Judiciary Act of 1789 confirmed the authority of a U.S. District Court judge, which is a constitutional Article III judge, to sit in equity as a chancellor in equity. That hasn't been changed. Claims court judges don't have that authority. They're not constitutionally created. They're created by Congress, and their authority had been limited exclusively to damages claims. Since its inception, it's been expanded recently because the judges do not have the equitable authority of a United States District Court judge. When we brought this action, most people thought we would lose, we'd be thrown out of court, because every tribal action prior to our individual action was brought in the claims court. They were limited to damages claims, and that was it. That's, of course, the reason. I know this is controversial, and I know Alex is going to cringe when I'm going to say it, but I'm going to say it anyway. But that's a reason when you brought the action for the Black Hills, you didn't get the Black Hills, so you got the damages. If you brought the action in equity, in restitution, restitution includes restoration of the original assets. That's what you would make a claim for. That is now over, for the most part, but that's how it was filed. That's not a criticism, by the way, because every single tribe brought their actions for their claims under the Indian Claims Commission Act, 1946, in the claims court for damages. The Indian Claims Commission Act strictly limited claims under that act to damages claims. Individuals are not subject to the Indian Claims Commission Act, never were, and their actions in equity and rights in equity were never limited. Nobody ever did it before Eloise did. Nobody ever did what we're doing. Now the tribes are trying to copy what we're doing in the U.S. District Court. They've also brought damages actions in the U.S. Court of Claims. We chose not to do that for a variety of strategic reasons, and we didn't think it would be helpful to do that. So what we did, I will tell you, was counterintuitive. Everyone said we were nuts, and everyone said we would get an end. What we have right now is the largest settlement in the history of the United States. I want to say one thing before we go on to some specific questions. Because I'm not an Indian, I don't pretend to understand all the problems and the terrible behavior that the government has exhibited to Indians, including murder, including lying, including stealing their assets and stealing their money. There's nothing. By the way, apologies are hollow. They mean nothing. I didn't have anything to do with it, but when I read it, and by the way, I didn't know about it either. I'm from the East. I'm originally from New Jersey. Lenni Lenape Indians were in New Jersey once. No one told us in school why there weren't Lenni Lenape Indians in New Jersey. That's Lenni Lenape banded in Delaware anymore. But they were killed off or chased out of New Jersey. History books were written for the victors, not for those who were vanquished, no matter how terrible that these facts were. So what I know, however, and what we've learned in this litigation is confirms the worst that you've ever believed. The government destroyed most of the documents, but not all of the documents. And what we learned from what has occurred over the years will make you cringe, even what you already know. And it's horrible. And Judge Lambert, the first judge in our case for more than 10 years, talked about it in an opinion that had him removed because the government argued that his opinion demonstrated he was unfairly biased against the government. He talked about the racism that was inherent in this entire, I don't even know what to call it, debacle for 200 years that was exacerbated later on. He talked about how what we're dealing with, even in the way the government litigated the case, were the last vestiges of the historical racism. And it's got to stop. And it was going to, and the Trail of Tears was going to stop at 3rd and Constitution Avenue, where the U.S. courthouse is situated. For that, the Court of Appeals, at the request of the government, removed the judge. The judge is the chief judge of the United States District Court for the District of Columbia. That's how powerful the opinion was and how afraid the government was as to what the judge was going to do in the judgment. Normally, in a trust, all presumptions and inferences are against the trustee. The duty and obligation of a trustee is to create and protect and preserve all trust records which identify all items of the trust, all transactions, and allow the trust beneficiaries to make an informed decision about the conduct of the trustee in his management of the trust. Well, let me tell you something, that's not what happened here. And the judge that replaced Judge Lambert didn't apply those presumptions. And the Court of Appeals didn't apply those presumptions. And as a matter of fact, one of the judges on the Court of Appeals said in the oral argument, I don't believe individuals are entitled to a penny. I don't believe they're entitled to anything. We nevertheless believe that applies. 95 years of precedent in the D.C. Circuit apply those standards. But the district judge who replaced Judge Lambert and the Court of Appeals judges, 3-judge panel, said, we're not going to do it, and they wouldn't say why. You could guess, but speculation doesn't help. What's very important here is that decision in July of 2009 reversed what the Court of Appeals held on February 23rd, 2001. And by the way, the law of the circuit and the rule of the circuit is first in time controls. Not second in time, first in time. The rule is that no 3-judge panel in the circuit court can reverse a prior 3-judge panel in the circuit court. But that's what was done in our case, in violation of the circuit's own rules. On February 23, 2001, the circuit unanimously held that the obligation of the United States is to provide a complete accounting for all funds, for all items of the trust since the inception of the trust. The Court of Appeals went further and said the United States government cannot use the absence of adequate appropriations as an excuse not to do it. The Court of Appeals panel in July of 2009 said, because the government destroyed much of the records, it would be difficult and very expensive to do a full accounting. Therefore, the United States government only has to do an accounting for what it said is the low-hanging fruit. That means if the trustee destroys documents, it isn't low-hanging anymore, is it? Doesn't have to do it. Worse, for whatever low-hanging fruit exists today, the government only has to do the accounting when it has sufficient appropriations to do it. So we were left with a decision that vacated the $455.6 million because we felt it was egregiously low and didn't even include the statutory interest that is obligated to be paid. By the way, since 1854, in one statute, prospectively, and since 1994, retroactively, under the Trust Reform Act of 1994. Explicitly, and by the way, the 94 Act says this is only for individual Indian trust beneficiaries, not for tribes. And the interest is to be paid retroactively since the date the first investment was made. The 1854 legislation says all trust funds held by the United States must be invested and must pay at a statutory minimum rate. The reason for that is it's just not Indian funds that are held in trust. It's not common, but the Smithsonian Institution is a trust. It is the Smithson Trust. Those funds have been held in trust, and Smithson, James Smithson, an Englishman, gave the money to the United States in trust to build what we have today as a Smithsonian Institution. Therefore, the mandatory obligation to pay interest on funds held in trust. Individual Indian trust funds have been formally held in trust since 1887. So that obligation existed even before the trust was created. There's another trust that existed in 1854 that was identified in the legislation, and that was the United States Military Academy, West Point. That was established funding originally as a trust, and Congress wanted to make sure those funds were invested and that there was interest paid on those funds as the endowment for the United States Military Academy. Nevertheless, the district court judge would not include interest on the $455.6 million. The Court of Appeals wouldn't even address the issue. The 455 was vacated. So in July of 2009, after all these years of litigation, what the Supreme Court said were the obligations of the United States were ignored by the Court of Appeals. Notwithstanding what the Court of Appeals had held in 2001. We were left with no time for the government to have to do an accounting. It could do it, if it ever did it, 20 or 30 or 40 years from now, or 50 years, or 100 years. Maybe never, who knows? So we go back and the judge calls us into chambers with the government, and he actually was frustrated himself. He says, I don't know what decision I can make that can be sustained on appeal. I don't know what the answer to this case is. I don't know if there's ever going to be a resolution. And I think it's critical for the parties to settle this because the government has risk too. We litigated the hell out of this case. We had 220 days of trials. We had 3,600 filings. We've had scores of government witnesses. And we had discovery and court orders out that the government can't witness. So the government wants to get out from under Cobell. We decided that too many elderly have died in the class, and too many infirm have died in the class. And by the way, we estimate that approximately 300,000 individual Indians have died since this trust litigation started. We've got to bring closure. We've got to bring some funds to the individuals, and we've got to have some accountability to the government. So we negotiated $3.4 billion out of nothing. And Eloise sat at the table and wouldn't budge on issues, and we were so close to breaking this, where there'd be no settlement. Most people believed there wouldn't be during this period of time. But this is how it came out. And if there's any change in this agreement, it will terminate by its own terms. If Congress doesn't ratify the agreement by approximately April 16th, it will terminate. And we'll be back in court, and we'll be back in litigation, and I don't believe we'll have a resolution within the collective lifetimes of everybody in this room, including Alex, who's one of the youngest people in this room. That's where we are. We think it is a remarkable achievement what individual Indians have accomplished here. On December 8th, 2009, one last point, December 8th, 2009, we're sitting in a press conference with the Attorney General of the United States, the Secretary of the Interior, Eloise Cobell. The President had just before the press conference issued a press release stating how important it is for this settlement. Eloise Cobell, an individual Blackfeet Indian, is standing on the podium with the Attorney General and the Secretary, two cabinet officials. First time in history, largest settlement in the history of this country, and one individual Indian on behalf of all of you is standing there. Individuals have never been elevated to the level of importance and significance that individuals are today enjoying the status. It is a remarkable achievement which will be used as a foundation and, as Eloise said, a stepping stone to go further. You are serious people. You are seriously considered. I don't know any individual, white man, black man, or any other individual who stood on a podium with two cabinet officials and a presidential statement saying, we have settled with him or her. It has never occurred in the history of this country before. So I applaud you as individual Indians, and we as lawyers are fortunate to have represented you, and we've done so as well as we could. This has been 14 years of litigation, where through most of the time, most of us haven't taken a nickel. I went through 8 years without taking 5 cents for what I was doing, and I didn't think I could possibly do it. I mean, not for expenses, not for anything. And I had to give up my other clients, which were some of the largest financial institutions in the world. I couldn't have time to represent them. So what we did is because of the importance that Eloise emphasized to us we had to do to win. Against our team of a handful of lawyers, we had 2 divisions from the Department of Justice, Civil Division and the Environment and Natural Resources Division, 2 U.S. Attorney's Office, the Denver U.S. Attorney and the U.S. Attorney for the District of Columbia, the Treasury General Counsel's Office, the Solicitor's Office of Interior, White House Counsel, and a little more than that. 54 private law firms representing government officials in this litigation. There were 6 of us. And we were working night and day, and Eloise was on the phone with us at 2 o'clock in the morning on Fridays and Saturdays and Sundays dealing with the issues. Nothing like this has ever been done before, and quite frankly, you've got to be crazy to do anything like this again. But it's done. And we hope to see a resolution. It's going to be your choice, by the way, not ours, if you want this to go forward. It's you who make that decision. By the way, Congress is going to make that decision in the first instance, but you've got 2 bites at this apple. First, Congress has to ratify it. Congress doesn't ratify it, you don't have anything. This baby's over. But tribes, believe it or not, have gone to Congress to say, don't approve the Cobell settlement. As a matter of fact, I will tell you something. Navajo are among the most abused individuals. They were being paid a fraction of what non-Indians were paid, and the tribe was paid for pipelines across their lands. Huge oil and gas pipelines. And the Navajo tribal chairman went to Congress just a week ago and said, don't settle the Cobell case. The tribal interests are more important than the individuals. Just put them on the shelf. What has the Navajo tribe done to litigate its claims? It did nothing but piggyback what we did. It copied our complaint and has been sitting there, like every other tribe that copied what we were doing because they thought it was impossible. And then when they said, oh my God, it can work, they copied our complaint. Nevertheless, and then you have tribes in the Northwest saying, don't go with Cobell. We want some of that money too. Well, I will tell you something. None of the individual Indian trust money is going to be going to the tribes, and that will happen over our dead bodies. It's your money, not the tribes. They're not going to get it through tribal credit programs. They're not going to get it anywhere else. And if you want to take it, fine, that's your call. If you don't want to take it, fine, that's your call. And if you want to use it to buy a 6-pack of beer, that's your call. It's time that the era that should have ended in 1951 and never should have started, which said individuals were presumptively incompetent and can't make their own decisions, ends. This case ends that era. In my view, no tribal leader should tell you what to do. Nobody from the government should tell you what to do. I shouldn't tell you what to do. You make up your own decision with the information that you have, and that's an informed decision, and it's your right to do so. Alex, you want to fill in on anything?
Can everybody hear me okay?
Yeah.
Okay. I think, as you can see, this is a, thanks Dennis, it's been a long case, it's very complicated, and we're here to answer any questions you might have about this, and we'll be here, like we've said, till everybody feels comfortable. There are a couple points that I want to make sure people understand, and Dennis has touched on them. This case does not involve treaty rights at all. This case, especially important to the Great Sioux Nation, this case does not impact the Black Hills in any way, shape, or form. This case this settlement will not have any impact on tribal program funds from IHS or any Indian education programs. Those funds are separate and are appropriated through Congress, through the Department of Interior and Bureau of Indian Affairs, the Department of Education, Department of Justice. These funds come from the Judgment Fund, which is a zero balance fund that is not appropriated. So this will not impact any programming funds that Indian tribes use. I think really those are the main points I wanted to focus on. Also, it is important to know about the voluntary sale of land. This is completely voluntary. There's been some rumors that this is tantamount to a Termination Act, or that this is working to reduce the land base of tribes. That's all incorrect. Individual Indians are going to have the option to sell their interest in land. The United States will pay them fair market value for that land, and that land will be under the tribe's control of jurisdiction. So this will work to restore the tribal land base, provide the individual Indian a fair market value payment for the money, without the tribes having to be out any funds. And so I wanted to make clear that your participation in this settlement does not require anyone to sell land. So I wanted to make sure that was clear. Eloise can probably talk more about the scholarship, but there's a $60 million endowed scholarship fund that will be used for individual Indians to go to vocational schools, graduate schools, undergraduate schools, to better themselves and to obtain secondary education. And that's, I know that Eloise, that was a heartland point for her, and she can talk more eloquently about it if the need arises. But that is a significant point that is not always acknowledged as being as important as it is.
I would just add that the $60 million comes from the $2 billion. So there were some rumors that the $60 million would be coming out of the IIM account holders' money, and if you decide to do the mismanagement of land, it's not coming out of that. It comes out of the $2 billion. And I think that the beauty of having a $60 million endowed scholarship fund is that it can be added to, it can be matched, and we already have people that are interested in the private sector to match that fund. It won't be managed by the government. It'll be managed by a private Indian educational foundation that has done superb work. So there are ways that we're controlling this to make sure that every individual Indian has an opportunity to go on to college. And I think that for like this college here, Sinte, how beautiful it is, and how beautiful this building is, and how many more people can actually access the college fund to attend school here. So I think it's a great opportunity. And one of the reasons that I fought so hard for a scholarship fund is I think the only way that we achieve and get out of this abusive relationship with the United States government is get our young people educated. We cannot ever let this happen to us again. We cannot repeat history again. So we've got to make sure that our young people are aware and that they continue to monitor the government. They become the smartest people around when it comes to land issues, and this doesn't happen to us again. And so I think that's, to me, that's the really beauty of this settlement.